Down goes Secure 2.0. Hi, this is financial planner Sean Mullaney. Let's discuss. Last year on the channel, I talked about a court case that involved the Omnibus bill, which also included Secure 2.0, which has dozens of changes to the retirement account laws, including delaying required minimum distributions. Well, guess what just happened? On February 27th, the Federal District Court in Texas issued a 120-page opinion, and it said that the House of Representatives, when it passed that omnibus bill, which included Secure 2.0, it did not have a sufficient quorum, and thus it was not able to enact legislative business. That makes Secure 2.0 in very perilous shape, very deep trouble. Now, here's the thing. The court ruling is a very narrow ruling. It only applies to the state of Texas to the extent the state of Texas was injured by the omnibus bill. And that has nothing to do with Secure 2.0. But here's the thing. Anyone can now go into court, and if they are negatively impacted by Secure 2.0, they can go into court and say, you know what, a judge in Texas wrote a very good opinion, very well researched, very well written and analyzed opinion, and he said that there was not a sufficient quorum for the omnibus, and thus Secure 2.0 is invalid. So Secure 2.0 is essentially built on a foundation of sand. It's not a solid foundation at all, and it may be going away. Now, look, this is subject to appeal, so this is February 28th as I'm recording this. Things could change, right? The Fifth Circuit could overturn this. The Supreme Court could overturn this. I'm going to link to the 120-page opinion down below. I've done an initial skim of it, and I have to say it seems pretty well reasoned, and it's sort of like a hockey goalie late in the game. It shoots down all the arguments the government was making, around the enrollment doctrine, around political question. There are all these different arguments the government made, and this judge just, dispenses of them pretty well. So look, there's no guarantee that his opinion would hold up through appeals, although we don't even know if this will be appealed. But the problem now is Secure 2.0, like I said, is sort of a house of cards. It could get overturned in any other court case because another judge could say, oh yeah, this was already analyzed and analyzed pretty well. Yeah, this is invalid. Or the next presidential administration could say, we're not even going to enforce Secure 2.0 because it wasn't properly passed and we have judicial precedent, so we're not even going to support it. So Secure 2.0 is a whole bunch of limbo right now, right? As a financial planner, I step back and I say, well, what does this mean for us and our clients? The first thing I will say is there are thousands of Americans who didn't take RMDs last year based on the purported delay in RMDs. I think you're fine. This is my own personal opinion, not advice for your circumstances. Talk to your tax advisors. But I would think the government would be stopped from going back and saying, you should have taken that RMD last year because the Secure 2.0 wasn't the law of the land. They argued in federal court it was, right? So I think the IRS would have a tough time forcing people to go back and take RMDs or assessing penalties when the federal government itself was in court arguing that Secure 2.0, which delayed RMDs for some people, was not the law of the land. So I think those people, I would not be losing any sleep there. But as a financial planner, I think we have to be now very careful when we're talking to our clients going forward. Hey, you were born after 1959. You don't have to worry about RMDs to age 75. I think that conversation is a different conversation today. I think you have to say, look, there's this uncertainty out there. And look, maybe there'll be an appeals case that overturns this. That could happen, but we certainly don't know that that's going to happen. We don't know what the next presidential administration is going to do with this. Heck, Congress could even take additional action. So I think we have to be a little more nuanced. We can't just say, oh, don't worry about RMDs till 75 if you're born in 1960 or later. I don't think we could just say that with a straight face now. Some other thoughts. A lot of the financial institutions did not rush to establish things like Roth SEP IRAs, Roth Simple IRAs. They're part of this Secure 2.0 law, and they've been validated, right? And I'll tell you this, they ain't going to do it now, right? They weren't eager to adopt Roth SEP IRAs, Roth Simple IRAs, Roth employee contributions to solo 401ks. Those things met the financial institution, said thanks but no thanks, And frankly, they've now been validated in that, and I don't think there's any way they're going to add those types of features to their offerings when there's this judicial uncertainty around Secure 2.0 and the ability to take that. One thing that's sort of interesting too is the IRS already has given us relief on the catch-up contributions, which have to be Roth for 401ks. They already delayed that by 2 years. What could happen theoretically is if the IRS doesn't further delay it, which I would think they might want to do now, but let's say they didn't. Someone could go to court and say, look, Secure 2.0 wasn't validly passed, so catch-up contributions don't need to be Roths, right? And I think they'd have a really good argument there if there's no change on appeal, which of course could happen. So, here's the big picture on Secure 2.0. I thought Secure 2.0 was wrong to begin with for getting this quorum clause issue. I never liked Secure 2.0. It said we have retirement savings challenges, so we're going to bolster employer plans. I thought that was the exact wrong approach. The right approach would have been to bolster individual plans, right? Companies don't retire, individuals do. We ought to shift and bolster IRAs, Roth IRAs. And now the tax laws are not only complicated, they're now uncertain thanks to this quorum clause issue. And it looks like the House did not act appropriately back in December 2022. So if I was Congress, look, I'm not 535 members of Congress, but if I were, I would repeal Secure 2.0 so that the tax laws are not uncertain, right? We ought to have at least certainty in terms of our laws. And then I would expand particularly Roth IRAs, maybe traditional IRAs. I'd have more credits for low-income savers, single families where there's a stay-at-home parent. They should get more credits for contributing to Roth IRAs, that sort of thing. This is a stay tuned thing. I'm going to link to an article by a legal commentator, Margot Cleveland. She's great. She's done some really good analysis on this case. I'm going to link her article. I'm going to link the 120-page opinion. Look, don't take my word for it. You go through the opinion. You be the judge and jury. I think the opinion is very well written and is convincing. Let me know what you think about Secure 2.0. It's now in limbo. Hope you enjoyed this video. If you did, please mash that like button and subscribe to my channel. I'll see you next time.